An FBI nominee sat before Congress, sweating under the lights, evading one question after another. This wasn't the usual back and forth of a confirmation hearing, it was a showdown. Senators pressed him on immunity deals, secret testimony, and whispered plans to gut the Bureau from the inside. And the more he spoke, the clearer it became he wasn't there to reassure the country. He was there to protect himself. From the very first exchange, the hearing carried a sense of unease. The nominee admitted he had testified before a federal grand jury in connection with the classified documents case. He acknowledged that he had invoked his constitutional right against self-incrimination, and he confirmed that prosecutors had compelled him to testify only after granting immunity. That admission alone would have been enough to shake confidence.
Senator, just to be clear, I did not participate in any of those DOJ
Sir,
decisions.
that's a yes or no question. Are you aware of any plans or discussions to punish in any way, including termination, FBI agents or personnel associated with Trump investigations? Yes or no?
I am not aware of that,
Thank you.
Senator.
There is no evidence of wrongdoing by FBI employees involved in these investigations. If you do pursue investigations of those involved, will you commit to using standard processes, including a standard review by the FBI Inspections Division and the Inspector General?
Senator, I will honor all those review processes.
You will honor those review processes.
Yes, Senator.
If these are actions that the FBI employees, if there are actions against FBI employees that do not follow those standards process that happen before you get in, will you commit to reversing any decision prior to your arrival so that those standard processes and the standard review by the FBI Inspections Division will take place?
I don't know what's going on right now over there, but I'm committed to you, Senator, and your colleagues that I will honor the internal review process of the FBI.
Have you made any commitments to anyone about pursuing any investigations or targets if you are FBI director?
Only violent criminals and terrorists.
Have you had any conversations with anyone on the transition team about pursuing any investigations or targets?
Only following the Constitution.
Again, are you certain?
That I have told people on the
Are you
administration.
certain? Have you had any conversations with anyone on the transition team about pursuing any investigations or targets?
Senator, to the best of my recollection, I've only said I will use the Constitution.
Have you discussed specific investigations or targets you would pursue as FBI director with the President of the United States?
Senator, to the best of my recollection, no.
Are you certain?
To the best of my recollection, no.
According to public reports, you were subpoenaed by the federal prosecutors to testify as a witness before the grand jury investigation investigating the Mar-a-Lago classified documents case. And you testified before the grand jury, correct?
Yes, sir.
And when you were before the grand jury, you pled the fifth on the basis of self-incrimination, correct?
I utilized my constitutional rights during that process with the advice and consent of counsel and appeared before that grand jury.
I will take that as a yes. And you are familiar, I imagine, with Section 6002 of Title 18.
Off the top of my head, Senator, not.
Well, Section 6002 is the immunity statute. Whenever a witness refuses to testify or provide other information before a grand jury based upon the privilege against self-incrimination, the court can order the witness to testify. The witness must comply with the order, but they receive immunity, which means that no testimony or any other information provided before the grand jury can be used against them in any criminal proceeding. You were compelled to testify as a witness in the Mar-a-Lago classified document case. Did you participate in any criminal conduct involved in that case?
Involved in which, the Mar-a-Lago classified documents case?
Yes.
No, I testified through compulsion by court order.
You received immunity for providing information that was self-incriminating. Do you remember the name of the prosecutor who questioned you?
There were multiple, Senator. I do not.
Was it one of the people, were any of them people that were fired this past week?
I have no idea, Senator.
Are you certain? You're under oath.
I'm aware that I'm under oath, Senator, and I have no idea, and I did not participate in the removal of any DOJ prosecutors.
What was the information you provided that you received immunity for?
Senator, I would love my grand jury testimony to be released, but as you know, that grand jury testimony has been sealed by the Department of Justice, and I'm not allowed to discuss it here.
Well, I find it troubling that you do not know the law here, and let me tell you what the law is. Rule 6 governs grand jury proceedings. Under Rule 6E, grand jurors, court reporters, and prosecutors are bound to secrecy. But witnesses are not bound by secrecy. You were a witness in the classified documents case. You are not bound by secrecy. You can tell us everything that happened in that room and everything you testified about. I'll ask you again, what information did you provide to the grand jury?
In this, we are agreement, Senator. Get my grand jury testimony. I want it made public. I asked the Department of Justice to make it public, and they refused to do so.
There is no legal bound against you telling us right now what you testified to.
When I asked for my transcript to be released, the
Sir,
Department
did
of
you or
Justice,
did you not commit a crime?
Senator, I did not commit a crime.
Then why won't you tell us what you testified to?
Because it occurred over the course of 3 weeks. I don't have the ability to recall everything I testified to, but I'm asking you to put my transcript
Did you testify to
out.
witnessing the President of the United States declassifying documents?
Senator, what I testified to is best captured by that transcript in real time.
So you're not willing to tell Congress, after making many pledges today about transparency, whether or not you testified to witnessing the President of the United States declassify documents. In the name of all the values you have said today, did you or did you not testify to witnessing the President of the United States declassify documents?
I testified accordingly and under oath, and I encourage you to get that transcript.
And by the law of our land, you are free to tell people, what are you hiding from Congress? Answer the question. Did you testify to witnessing the President of the United States declassifying documents, yes or no?
Senator, the grand jury testimony is available to you. I encourage you to make it public.
As you likely know, the second volume of Jack Smith's report about the classified document case is not public yet. To fulfill our constitutional duty of advice and consent, the President, on nominations, members of this committee have asked the DOJ to review the report. Do you agree that Congress should thoroughly review its nominees? Yes or no?
Yes.
Okay. Now, last question and I'll be done.
But what followed revealed a pattern that was even more disturbing. When asked what he had actually testified about, he shut down. He reminded the committee that his words were under seal, that only the Department of Justice could release his transcript. But here's the truth many viewers might not know: grand jury witnesses are not bound by secrecy. Prosecutors and jurors must keep quiet, yes. But witnesses, they can share their own testimony freely. Senators reminded him of that. They pressed him again. Still he refused. And in that refusal, suspicion grew. If he believed in transparency as he claimed repeatedly, why would he hide behind technicalities instead of simply telling the truth? This is where Senator Cory Booker changed the tone of the hearing. Fighting the flu, Booker still hammered away with the kind of precision that cuts through excuses. He pointed out the legal reality. Nothing prevented the nominee from describing what he told the grand jury. No gag order, no confidentiality requirement. Just a personal decision not to speak. And that personal decision raised the stakes of the entire confirmation. Because silence wasn't about protecting the law, it was about protecting himself. Viewers watching might have felt the tension building. If someone seeking to lead the FBI couldn't answer basic questions about his own past testimony, how could he be trusted to oversee agents across the country? Booker pressed again, asking whether he had witnessed classified material being declassified. The nominee dodged. Booker reminded him, by the law of our land, you are free to tell us what you saw. Still nothing. Each dodge turned the spotlight brighter. Each non-answer revealed a man more committed to survival than to truth. But that wasn't the end of it. Senators dug deeper, asking whether he had promised anyone that he would pursue particular investigations once in office. His answer, a vague line about following the Constitution. Pressed again on whether he had discussed targets with political allies, he repeated the same phrasing word for word. It sounded less like conviction and more like rehearsed deflection. If you listened closely, the silence around the specifics was louder than anything he actually said. And then came the topic of firings. In recent weeks, reports surfaced that multiple prosecutors tied to sensitive investigations had been removed. When asked about this, the nominee flatly denied involvement. But when asked whether those prosecutors were the same ones who questioned him before the grand jury, he claimed he had no idea. Senators reminded him that he was under oath, still he wouldn't budge. For a man promising transparency, he was remarkably unwilling to confirm even the most basic facts. This hearing wasn't just about past events, it was about the future of the FBI itself. That's why the most explosive moment came when Booker raised a different subject, the nominee's plan to restructure the Bureau. According to their private conversation, the nominee had talked about removing as many as 11,000 personnel. 11,000. He had even floated the idea of shutting down the Bureau's headquarters, the Hoover Building, altogether. And who would replace those thousands of non-political career employees, political appointees? In one of the only agencies in government that traditionally has no such positions, he wanted to install loyalists. Think about that. The FBI, long held up as an independent investigative body, insulated from partisan battles, being transformed into an organization staffed by political operatives. That isn't reform, that's takeover. And Booker made that clear. He accused the nominee of preparing to gut the Bureau from the inside, not to strengthen it but to weaponize it. In that moment the stakes of the hearing crystallized. This wasn't about one man's evasive answers, it was about the integrity of an institution. The nominee's defenders argue that he was simply cautious, that he didn't want to get drawn into public disputes over ongoing investigations. But caution doesn't explain immunity. It doesn't explain the Fifth Amendment plea. And it certainly doesn't explain his refusal to share testimony that he was legally free to discuss. The more likely explanation is far simpler. His answers would have revealed truths too damaging for his nomination to survive. And this isn't speculation pulled from thin air. Over the years, the nominee has cultivated a reputation for loyalty above all else. Critics argue that his career has been less about serving institutions and more about serving powerful allies. His language in the hearing only reinforced that perception. Over and over he spoke about loyalty, about following orders, about honoring the Constitution in broad strokes. But when pressed for specifics, names, actions, details, he shut down. That contrast between lofty words and evasive silence spoke volumes. Some observers might wonder, why does any of this matter? After all, hearings are full of political theater, but this one matters because the FBI isn't just another agency. It carries the power to investigate, to prosecute, to protect national security. And placing someone at its helm who arrives with immunity baggage, with evasions on the record, and with a blueprint to purge thousands of career professionals is more than risky. It's dangerous. And the danger doesn't stop with structural changes. Imagine the chilling effect on rank-and-file agents, knowing their careers could be ended not for misconduct, but for failing to show political loyalty. Knowing their investigations could be shut down, not for lack of evidence, but for crossing the wrong person. That fear alone could bend an institution designed to stand upright. Booker's final words cut directly to that point. He said the nominee wasn't there to lead the FBI, but to hollow it out. And watching the exchange, it was hard to disagree. The nominee had dodged too many times, hidden behind too many technicalities, and avoided too many opportunities for honesty. By the end, the picture was clear. He had something to protect, and it wasn't the law. Let's step back and connect the dots. First, a grand jury appearance, a Fifth Amendment plea, and immunity. Second, a refusal to discuss testimony despite being legally free to do so. Third, vague denials about conversations with political allies. Fourth, a suspicious lack of knowledge about prosecutors recently removed. And fifth, an open plan to restructure the FBI with political appointees. Each of these on its own would raise questions. Together they form a pattern of evasion, ambition, and design. And the design is what matters most, because this isn't just about one nominee, it's about the precedent of politicizing the FBI. Once that line is crossed, it's nearly impossible to walk back. Other institutions have been politicized before, from regulatory agencies to intelligence offices, but the FBI's independence has long been considered sacrosanct. Weakening that independence would mean weakening the very fabric of oversight and accountability in the justice system. Critics warn that we are already seeing signs of erosion. Whistleblowers claim that internal discussions about personnel removals are happening behind closed doors. Former officials warned that installing political appointees would open the door to selective enforcement, and legal scholars point out that immunity deals for senior nominees are virtually unheard of, raising red flags about hidden liabilities. Against that backdrop, the nominees' hearing wasn't just uncomfortable, it was alarming. The most striking moment came when Booker asked, directly and repeatedly, "Did you or did you not testify to witnessing classified documents being declassified?" It was a yes or no question. Instead of answering, the nominee insisted his transcript should be released by the Department of Justice. Booker countered that nothing stopped him from answering now, in public under oath. Still, he wouldn't say yes, he wouldn't say no, he wouldn't say anything at all. And in that silence, a nation saw what it might mean to put him in charge of the FBI. That's why this hearing is more than political theater, it's a warning shot. It shows us the dangers of placing loyalty above law, silence above truth, and politics above justice. Senators may frame it in legal terms, but for the rest of us the question is simpler. Do we want an FBI led by someone who won't even answer the most basic questions about his own past? Because if this is how he behaves under scrutiny, dodging, deflecting, hiding, what happens when the spotlight fades? What happens when he has the power to shape investigations, to assign or remove agents, to decide which cases move forward and which disappear? Those decisions affect not just Washington, but every community across the country. The nominee promised transparency, he promised accountability, he promised to honor the Constitution, but promises are only words, and words without answers are empty. What we saw in that hearing wasn't transparency, it was concealment, it wasn't accountability, it was avoidance, and it wasn't honor, it was evasion. For a moment, consider the long arc of history. Agencies like the FBI were created not just to enforce laws, but to reassure the public that those laws apply equally. Undermining that mission risks undermining faith in justice itself, and faith, once lost, is nearly impossible to rebuild. So when you think about this hearing, don't just remember the dodges and the deflections, remember the bigger warning it carried. If a nominee hides this much before taking office, imagine what he might hide after. If he refuses to answer when senators hold the power of confirmation, imagine how little he'll answer once he holds the power of the Bureau. And that is the sobering truth. The hearing wasn't about past controversies, it was about the future of an institution. It was about whether the FBI will remain independent or become another tool of politics. The nominee's silence gave us the answer he wouldn't say out loud, and the answer should concern every American. So ask yourself, if transparency is optional before power, what will it become after power? If accountability can be dodged at a hearing, what will it look like inside the walls of the Hoover Building? And if the Constitution is just a word to recite instead of a standard to uphold, what happens to the very system it was meant to protect? This was more than a tense exchange. It was a glimpse of what could come, and it left us with one final chilling question. If this is what he hides before stepping into the role, what will he conceal once he controls the most powerful law enforcement agency in the nation? Like, subscribe, and share to keep these hearings in the spotlight. And remember, accountability only works when we demand it.